I'm interested in what the President of the Law Society has just said about the fact that the Law Society has nothing to do with the arrangements for handling negligence claims, because I have in front of me a memorandum which was issued by Mr Mill in connection with the case of one of my constituents on the 5th of July 2001, and I don't know if it's available in the evidence base of the committee, but I know the convener has it already, and I'm happy to pass that on. Which
the committee has.
The committee has that. That's fine. Which. Certainly, in the terms of Mr Mill's memo, it's a memo to the then President of the Law Society, Mr McAllister. It also involves reference to the brokers of the master policy and the master policy that suggests that it would be good if we all got together, and I quote Mr Mill, and have a summit meeting to discuss how to dispose of my constituents' several valid claims. Now, I find that, and Mr Mill and I have discussed this at length over the years, but I do find that a rather strange memo to sit comfortably with the statement the President has just made.
Well, Mr Swinney, for reasons that are clear, I'll get Mr Mill to answer that, because that was before my time.
Yes, Mr Swinney and I have discussed this on several occasions over the last few years. I would actually say it goes a long way towards proving that we don't dabble in individual claims. I'll go on oath and on record and swear in my granny's grave that never once have I or any member of my staff, or indeed any office bearer, ever dabbled in a claim. What I am saying here is there are various parties. If you take Anne to be the Law Society, she in turn tenders the master policy brokerage on a 5-year rolling programme with Philip, who is the broker Marsh. He in turn buys it in the market from me, the RSA, as the lead insurers, and the other insurers each year, and when necessary they would instruct Caroline as the panel solicitors. Now, this is the sharp end of claims being dealt with. The layer of insulation between the Law Society and claims handling is Marsh the broker. And our President then, Martin McAllister, got a letter from Mr Swinney's constituent, and I think probably the committee will accept that many letters which our President gets are perhaps not with the same degree of foundation that Mr Mackenzie's issues have been. And I was asked to give a briefing, and I quite properly inquired of Marsh. I said I seek an assurance that these complaints, these claims are being progressed quickly, and that's what I get. I give my President an assurance that I'm satisfied, having been satisfied by Marsh, and this is all set out in the Marsh response which I refer the committee to. I have been satisfied by our brokers that our insurers and their solicitors are acting expediently here, and that message was relayed back. That's the sum and substance of it. If we did dabble in claims, it would be a very different memo.
I think for the sake of the record, I just would like to place on record the fact that the memo of the 5th of July encourages a summit meeting on the up-to-date position, looking at both the complaints and the claims aspects, which rather suggests to me that the Law Society have been involved in this area. And just also for the record, I would point out that this claim remains unresolved today, and this memo was dated the 5th of July 2001, and I appreciate your indulgence, Convener, to allow me